There are about 7,000 cases each year that petition the court to be heard. That's right, 7,000. But the Supreme Court only hears maybe 150 cases a year, and that's still a lot. Stop it, you're hogging my scene.
The Supreme Court hears cases from October till late June or early July of each year. This time is called the Supreme Court's term. The term is divided into 2-week periods when the court is either sitting or recessed. When the court is sitting, it hears cases and delivers opinions. They can hear up to 24 cases in just one sitting. When the court is recessed, the justices work on their opinions and study upcoming cases.
Remember, we already told you how a case makes it to the Supreme Court. It must first be considered in the trial and appellate courts. Then, if there is still a difference of opinion, one of the parties can take the case to the Supreme Court in the form of a brief. If they are lucky, a writ of certiorari is granted, which means the case makes it to the court's docket. But you should already know that, wink wink. However, you may be wondering what factors keep a case from getting onto the docket.
Politics are a big factor. If the Supreme Court thinks a case is too political, which means they think it would be better handled in Congress by the passage or amendment of laws, then the 9 justices will stay away from it. The other reason justices may decide a case does not merit Supreme Court consideration is if, in their opinion, the case is already clearly decided or not worthy enough to be heard in the highest court of the land. Due to the volume of cases trying to get onto the Supreme Court docket, the justices must restrict the cases they hear to those that will have a substantial impact on the nation.
So, if politics and banality don't get in the way, you're on the docket, which means you need to be preparing for oral arguments.
Oral arguments are when each side of the case has a half hour to argue their side of the case while the Supreme Court justices ask the lawyers any questions they want about issues behind the case.
Just a half hour? Well, this may sound like it's not a lot of time, but remember, the justices have already read extensive written arguments.
After these arguments, if the justices still aren't satisfied that they have enough information, they schedule a re-argument. Otherwise, the case moves forward via the conference.
The conference is when the justices get together in secret and talk amongst themselves about the case. The speaking goes in order of seniority. The Chief Justice presides over these discussions and presents each case first.
Eventually, they all stop talking and exchanging memos and start voting. The majority vote wins. The majority vote must be at least 5-4 when the court is full. After the vote comes the writing of the opinion.
The writing of the opinion is when the majority side of the vote puts its opinion down on paper. This is called the majority opinion. If the Chief Justice is part of the majority, he or she decides who writes the opinion. Otherwise, the senior member of the majority decides.
The opinion must be drafted, then agreed to by each individual member of the majority. There are also a few different kinds of opinions that can be written.
A concurring opinion is an opinion written by a member of the majority decision that disagrees with the reasoning. A dissenting opinion is an opinion which disagrees with the majority and discusses the minority opinion.